This is an educational video intended to explain the inventive step required for standard patents. For an inventive step to be patentable, when compared with the prior art base, the claim must be novel and it must involve an inventive step. With section 18 in mind, let's look at some key definitions regarding inventive step. First of all, invention means any manner of new manufacture, the subject of letters patent and grant of privilege within section 6 of the Statute of Monopolies, and includes an alleged invention. Prior art base is defined in Schedule 1 of the Patents Act, and essentially the prior art base is the information that is made publicly available. An inventive step essentially means the inventive process that the inventor took when making the invention. This involves the question of whether a non-inventive or particularly non-imaginative skilled worker would have found it obvious to make the step actually chosen by the inventor, and this was found in Minnesota mining and manufacturing case. So to look back at section 18(1)(b) with these definitions in mind, add some perspective as to what section 18 is essentially saying, and that is, for any manner of new manufacture to be patentable when compared with information that is publicly available, the claim must be novel and it must involve an inventive process which is not obvious to the skilled worker of that field. Section 7 of the Patents Act defines inventive step. Would the invention have been obvious to a person skilled in the relevant art when compared to the common general knowledge as it then existed? Windeye J illuminated in the case of Sunbeam Corp and Morphy Richards that inventiveness is determined by examining whether the thing in question was obvious or whether it had required an inventive step to produce it. A test for distinguishing whether something is obvious to a person skilled in the relevant art was clearly set out in Insta-Image and KD Canopy Australasia, whereby in paragraph 80 it set out 5 steps. Step 1 was to identify the invention, so far as claimed in any claim. Step 2 was to identify the person skilled in the relevant art. Step 3 was to identify the common general knowledge as it existed in Australia before the priority date. Step 4 was to inquire under section 7.2 whether the invention referred to in step 1 would have been obvious to a person referred to in step 2 in light of the knowledge referred to in step 3. And step 5 was to inquire whether that invention would have been obvious to the person in light of that knowledge when that knowledge is considered together with either kinds of information mentioned in section 7.3. Additionally, further tests include, as derived from the Minnesota mining and manufacturing case, whether the invention provides a solution to an existing problem, also whether the solution has been awaited for years and is a commercial success, or if the solution comes from a completely different area to which prior research was going, and also as derived from Mayers, Taylor and Vicar Industries, where the new invention is given preference over the prior art. Now, the Raising Bar Amendment has slightly altered the current standard of inventive step. The recent amendment has set out that all prior art is available for assessment regardless of whether it originated within Australia, irrespective of whether the inventor could have ascertained, understood or regarded it as relevant. Prior art sources may be combined so as not to give the effect that the inventor could simply search through patents and combine them for an invention of their own. And the assumed common general knowledge of a skilled worker in the relevant area is based on a global standard as opposed to being limited to Australia. So to summarise, inventive step does not necessarily have to be a large thing. It merely has to have something that makes it unique. The invention, well, it has to be inventive, and that is determined by contrasting the obviousness of a person skilled in the relevant area with the prior art base.